टिकિટ ના પૈસા નથી ભર્યા, પૈસા ભર્યા તમે ટિકિટ ના?
हाँ सर,
ટિકિટ ના પૈસા ક્યાં ભર્યા એની રિસિપ્ટ?
एक मैं साहब रजू कराई दो सर।
તો બધું એક એક વસ્તુ રજૂ શું કામ કરવી છે? શેડ્યુલ કીધો તો પછી આપી જ દેવાય ને. આમાં ખબર કેમ પડે કે સાચી ટિકિટ છે ખોટી ટિકિટ છે? ટ્રાવેલ એજન્ટ આપી દીધી હશે.
ये सब वो रजू कर दो सर परिवार में।
15 દી જવાના છે?
हाँ खाली 15 દિવસ છે।
15 દી ફરશો ને?
हाँ 15 દિવસ માટે ખાલી 1/5 જવાનું છે અને 15/5 એટલે 16/5 અમદાવાદ રિટર્ન।
તો ઇન્ડિયામાં ફરો ને.
From that charge sheet, I just want to show some documents.
કયો જીપીઆઈડી કેસ કયો છે?
19 of 2020. So that may be taken as a lead matter, so that from that charge sheet papers I can.
યસ.
May I? Now, this offense under section 406, 420, 409 and 120B read with section 3 of the GPID Act. These are the sections. Now, as far as this present applicant is concerned, I am accused number 2.
You're accused number 8.
Sorry, I'm stand corrected. Accused number 8, yes. Neha Bhandari. Now, may I just before brief facts of the case before I proceed on my submissions on discharge. May I state the facts? આ કામના આરોપીઓ સોવરીન ભંડારી, who is the main accused number 1. He was my erstwhile husband right now. Since now I am legally divorced from him. Rahe so and so. Maruti Krupa Agri Producer Company Limited. This is the first company. Bosses may kindly consider it. ધરાવી ગ્રાહકો પાસેથી recurring FD, MIS દૈનિક કલેક્શનની સ્કીમો ધરાવી તેના ઉપર વ્યાજ આપી સ્કીમ સમજાવતા માટે ચેરમેન ફાઉન્ડર સોરીન ભંડારી અને પ્રમોટર નેહા ભંડારી. Now the prosecution is alleging that I am also one of the promoter of the said company. Now I will show from the record that this is a totally incorrect. અને ત્રિવેન્દ્ર કુમાર મર્સિડીઝ કાર નંબર 100 મેટ્રોપોલિટન કોર્ટ ખાતે 2009ની આશામાં આવતા હતા, પરંતુ તેઓએ સન 2015 થી ઉપરોક્ત ફર્મ શરૂ કરવામાં આવેલ, તેમાં સોરીન ભંડારી ચેરમેન તરીકે હતા, that is accused number 1, અને નેહા ભંડારી so મારુતિ કૃપા એગ્રી પ્રોડ્યુસર કંપની લિમિટેડના પ્રમોટર તરીકે કામ કરે છે અને તેઓ આ કંપનીનો વહીવટ કરી સારું અન્ય ડિરેક્ટર્સ so ડાયરેક્ટર તરીકે છે. ઉપરોક્ત ઓફિસ સિવાય અમદાવાદમાં અન્ય 14 સજાનંદ કોમ્પ્લેક્સ. Now I am reading the transaction which is alleged in the present FIR. ઉપરોક્ત કંપનીના ચેરમેન ફાઉન્ડર પ્રમોટર નેહા અવનાવર ફરિયાદીના ઘરે આવતા તેઓ કંપનીની જુદી જુદી સ્કીમો બાબતે સમજાવી તેમાં રોકાણ કરવાની લોભાણી વાતચીત કરી ફરી કંપનીના ઉપર વિશ્વાસ બેઠીને અમોએ તારીખ 28/9/2019 રોજ ₹25,000 ફરિયાદી શ્રીના દીકરા so મૂકેલા, તારીખ ₹25,000 ફરિયાદીના પતિના નામ મૂકેલાના દૈનિક યોજનામાં અલગ અલગ ચોપડાઓમાં ULC કંપનીના ₹2,61,000 જમા કરાવેલ તથા ફરિયાદી શ્રીના નામે પતિના નામે UNL કંપનીમાં રૂપિયા એમ કુલ રૂપિયા 6,78,000 ફરિયાદીશ્રીના પરિવાર તોમતદારો જુદી જુદી કંપનીમાં રોકાણ કરેલ સદરુ રોકાણની સામે તોમતદાર ફરિયાદીશ્રીના જુદી જુદી તારીખના ચેકો આપેલ, તેમાં એક ચેક રિટર્ન આવેલ છે. તે ઉપરાંત ફરિયાદીશ્રીના જેઠ પંકજ શાહ જે વકીલાતનો ધંધો કરે છે તેઓ પણ આ કંપનીમાં રૂપિયા 1 લાખની ફિક્સ ડિપોઝિટ કરે. Now after this કુલ રૂપિયા રોકાણની પરંતુ પાકતી મુદતે તેના નાણાં મળવા પામેલા નહીં. આમ ઉપરોક્ત સોરેન મંડારી અને તેના સાથેના અન્ય પ્રમોટર ડિરેક્ટર ભેગા મળીને ગુનાહિત કાવતરું ગુનો કરેલ છે. So there are two companies. One is Maruti Krupa Agri Producer Company Limited. Now they floated a scheme wherein it is alleged that the present complainant invested some amount. Now, as far as my client is concerned, my first submission is neither I am promoter in the company, nor a director, or shareholder, or I am not involved in the management or affairs of the company.
Yes.
Now the purpose why I am roped in, just to see that I may be pressurized. This is the only purpose. Now I will show from the record that whatever receipts for the fixed deposit issued by the accused number 1, there is no signature whatsoever, neither on check nor on the receipt of the fixed deposit. There is no signature. And this is an admitted position of fact which is not denied by the prosecution also. Now the allegation is pertaining to a company who floated a scheme for some kind of investment and promised some return. Now, as I narrated from the FIR, the entire allegation is qua to the company operated by board of directors, that is accused number 1, and then the alleged fraud they played, which is the part of the story. Now please, now my first legal submission is that if a company who perpetuated the fraud, or maybe a scheme, fraudulent scheme, or maybe a Ponzi scheme, then company is also being a legal entity, a body corporate who is registered under the Companies Act, is also required and necessary to be made party in the FIR, in the charge sheet, and the company is also liable to be prosecuted. This is my first submission. Because there is no personal transaction which has been carried out as narrated in the prosecution. The company is not made a party. Now second, state may argue that company may not be necessary. Now what is the repercussion under the law? The repercussion would be, sir, company being a corporate body, like we have a partnership firm which is run by partners. There is a special act. There is an Indian Partnership Act and there is a LLP, the Limited Liability Partner. Similarly, for a company, there is a Company Act. Now, a company can only govern by the board of directors. Now, there is a doctrine of vicarious liability is very important. If a company has committed some offense, then the directors are also liable. But in what condition? Unless the company is not prosecuted or joined as a party accused in the prosecution, directors cannot be held liable for that purpose. So for attracting doctrine of vicarious liability, it is necessary that a company has to be a party prosecution.
Okay.
And that is how the directors could be roped in. So this is my first submission, company is not made a party. Second submission would be, what is my status in the entire transaction as far as my client is concerned? I am on a better footing. I am neither a director, nor a shareholder, not even a promoter, or not even a signatory to show that I was involved in the management of the company. Even I am not present for the alleged transaction which occurred at the relevant point of time. Now, to demonstrate this fact, how the investigation has been carried out by the learned investigation officer, where in the part of charge sheet, he has annexed the ROC documents, which I will show to your honor, wherein nowhere I am shown. Then also in the reply filed by the prosecution, without even verifying the veracity of the facts, they have blanketly stated in the FIR and charge sheet that I am a promoter somewhere it is written I am a director. This is the irony of the reply and the investigation. Now, if a honorable court may see the charge sheet,
Quashing petition was rejected.
quashing petition was rejected.
This contention was raised.
This contention was raised.
So this
I
is
went to Supreme Court.
get withdrawn.
Supreme Court said we file a
Discharge.
discharge. But sir, quashing parameters and discharge parameters are totally different. I will also take to the honorable court order of quashing also. There also the honorable court has said that all my contention which I submitting,
That are kept open.
that is correct. Legal proposition are not disputed. But why in the quashing petition the honorable court did not grant me the relief only on one point, that there are mere statements where they have said that my photo is shown on a picture. Now that photo is also not there. That is the only statement, piece of evidence to prosecute me. So the honorable court said that since there is a very limited in the quashing petition, the honorable court said that you prefer a discharge. I went to Supreme Court. The honorable Supreme Court has also said that on merits, the honorable court is not going. And this is how I file up this petition. Because as far as my discharge application is concerned, the law is settled on the ground that the honorable court has to weigh an evidence to show that whether on this piece of evidence.
Now it is on the basis of evidence. So far as your legal contention, which was raised for the High Court,
High Court.
as well as before the Supreme Court,
Yes.
that has been considered and that your application are not considered so far as legal contention with regard to company being not joined as an accused.
That contention was raised, but since the honorable court has said that you avail a remedy of
Whether
discharge.
There is no,
Yes.
so now discharge would be governed by this discharge proposition, okay, whether the evidence collected.
So, but that is also, this is also one of the ground where the court, honorable court will has to consider it. Suppose if company is not made, that is what I am coming to the
So
point.
your contention was already, whether you had raised this contention before High Court or not.
Yes, we have raised.
There the court is not satisfied on law point.
No, but sir, that
Since
see,
company is not joined as accused, therefore this entire case would fall.
Paul, yes,
So
yes.
that is not considered.
No, but if assuming that is not considered, but whether that argument was pertaining to quashing of FIR.
Quashing.
Today I am making a submission for the framing of charge. That before framing of charge, whether there is an ample evidence to show on record that I can be
Evidence-
prosecuted.
Yeah, that is different thing. That I
Yes.
am not telling. I am telling so far as this contention with the company is concerned.
Yes.
So that was raised before.
Even the honorable court has admitted that the contentions are right, but only for the statement purpose. The honorable court has said that he is not inclined. That if a lordship may want, I will just read that last paragraph.
Anyway, we'll go by first week discharge, but this is the.
No, just since the honorable court has raised the query, just give me 1 second. Just last paragraph of the operative part of my order, where I want to just read. May I read only just last paragraph? Considering the above mentioned judgments, it is required to be considered for the facts of present, and therefore I found no merit in the present petition. The ratio of the judgment laid down by the learned advocate for the petitioner cannot be disputed. But in the peculiar facts and circumstances of the present case, where there is a specific allegation against the petitioner in her individual capacity, is also made. This is what, and this is therefore the judgments are not applicable. So the ratio is not disputed. Now I am making because my submission in before the High Court was pertaining to a quashing petition, that it is an abuse process of law. Here I would make a submission to the honorable court and try to convince it.
Abuse of process of law would be a different contention.
Ha. That is for high quashing.
No, no. For making that submission, you would have to show that it is abuse of process of court law.
No, for quashing, I have to satisfy the
For
honorable.
abuse of process of law, you can say a multiple FIR are filed for the same transaction. That can be considered as an abuse of process.
Processor.
Now, the contention with regard to company not being made an accused, though it is a legal entity, that would be a legal submission.
But that is also abuse process of my contention when I raised also to show on record that unless company is not made a
So this
party.
both abuse of process of law and your legal contention, which now as per your, that has been raised already before the High Court and before the Supreme Court. That has not been considered.
Yes.
Now the discharge parameter would be whether this evidence collected would be sufficient to put the accused for trial or not.
Yes. Yes. Yes.
Because your other both.
No, but
contention
now
are-
I am. That is what I am trying to.
as far as abuse of process of is concerned, that would not be part of discharge application.
No, now in discharge, I have to convince the honorable court that even with this evidence, if a charge is framed and trial is concluded, then it cannot be even framed. That is what my submission is. Now, how? That is what I am just about to.
That
Make.
I would, so that you might be clear, I may also maybe, I don't know.
Yes.
You might be making all your attempts. So far as abuse of process part is concerned,
Yes.
whether that can be a subject matter of a discharge application.
No, but now I am not making on that
So
submission.
far as discharge jurisdiction is concerned, it is whether the evidence
Yes.
correct
Yes.
is sufficient to put him for trial,
Yes.
whether the sections which are you are charged sheeted for the sections, whether that gets attracted or not. On
Yes.
the basis of evidence.
Evidence.
You see, if it was your abuse of process of court law, then that would have been taken care by the higher court. That has not been done.
Done. But sir, again, if I am saying that the High Court and the Supreme Court has said that we have not gone into merits, and that submission,
The evidence
Ha.
evaluation.
assuming, sir, whatever it is a question of law, my legal submission and facts. Now the Honorable Court, as Supreme Court has clearly said that this Honorable Court will not be influenced.
I'm not saying that
Ha.
discharge would not lie at all.
Not
Or
lie.
discharge should be straightway rejected.
No,
I'm not telling that.
Even I am,
I'm telling that so far as abuse of process of
yes,
that argument can't be
but I am not
yes.
making that argument. What I am trying to convince, why companies are necessary, that is what I am, for the purpose of discharge, I am arguing.
yes.
I am not arguing for the purpose of abuse process. Or now that contention, I have not at the stage of 482.
And that is very much clear.
Yes,
Court
yes,
has said, that will be considered on merit discharge.
Yes,
The Supreme Court has said that.
yes. But
Whether
why
it-
I am emphasizing
So far as it is confined till discharge.
discharge only. Yes, yes, yes. Now I am trying to, that is what, now I am making my submission in a very more appropriate way to convince this honorable court that why the company is necessary for the purpose of trial. Because the law says that if company is not an accused, then the directors would not be vicarious liability, even for the criminal prosecution. And there are catena of judgment to the effect.
There
Suppose
are also catena of judgments, any accused can be joined during the course of trial if required.
that 319 application that may come, yes, but that is after recording of evidence. 319 stage would come after the recording of evidence.
Can be at the stage of any stage during the course of trial.
No, as
That
far-
evidence can be recorded.
with my limited understanding, there's a law is that for 319 for joining any accused at any stage of trial would begin after the recording of
If
evidence.
someone is left out at the time of filing of charge sheet also, then he can be called upon. The framing, he is also an accused.
Now the prosecution cannot join unless the evidence is recorded.
So this is one month.
This
Yeah,
is
it can be
academic
very-
discussion. I am just trying to enlighten that at what stage the prosecution can join accused. Now here what is my contention is there are twofold contention. Now why I am on a better footing, 2 point which I like to convince.
First point, that is company, that I have taken.
Company.
Now second is that you are not a promoter, director.
Director, shareholder, anywhere in the party.
On that point, you can now point out.
Yes. Even not I am an employee of the company. Now to show this, in the charge sheet there are ROC records the investigation authority has put on record, ROC papers. In the ROC record, I am making a very responsible submission that my involvement in the affairs of the company is not shown, because my involvement would come either I am a director, either I am a CEO of a company, or an employee or an officer.
So in a ROC record, you are nowhere.
I am nowhere. So if in the management I am not holding any capacity in the company, I am not involved in the affairs of the company. This is my first submission. Now, I am saying from the date of incorporation of the company, not anywhere, but
Anyway,
anywhere. Yes. Now, my second submission would be, state would make a submission that there is an individual capacity I am involved. That would be another submission. Now, to counter that submission, my reply is that it's a case of a documentary evidence case. That is not in dispute that the money was taken as a fixed deposit or any scheme. And pursuant to that, a receipt is also given. A check is also issued. Now, in that, it bears no signature of my client. No signature.
that I have recorded. Okay, no
So-
signature on receipt or checks.
Check. Or even any document whatsoever. Part of charge sheet, because I have to confine charge sheet papers only as far as discharge is concerned. So now, assuming if I have to frame a charge under 406 and 420, there has to be some money has to come in my account, or I am a beneficiary of the transaction. Now, earlier also I made this submission. Again, I am making submission that charge for 406, 420 cannot go together. Either I have committed a criminal breach of trust or I have committed cheating. The paramount consideration, the ingredient is that the property, there should be entrustment of property. If I have taken a property entrusted with me, for example, his money is treated as a property of the complainant, is with me or with the company, then it is a case of criminal breach of trust and not cheating. So the charge would be under 406. If, assuming that I have sold some property, for example, I am selling Taj Mahal, showing that I am the owner of the property. Taj Mahal. Suppose Taj Mahal vechi kaadu.
You are the owner of that.
No, I am not owner. I am saying for cheating purpose. I am just giving an example. If I sell Taj Mahal to some person depicting that I am the owner of the property, so that property was not entrusted to me.
Yes, yes. Yes.
So this is the only distinction lies that 406, 420 cannot go together. So either my case would fall under 406 or 420. Now, assuming as far as role of my client is concerned, there is no evidence to link up, because there would be a mere statements. Now, in the case, this is not a case of circumstantial evidence. It's a case of a pure documentary evidence where the prosecution has to show a linkage with the committal of my offense. So even the charge, neither I have committed cheating nor criminal breach of trust. Now, as far as 409 is concerned, now this section is added because the offense becomes more than 7 years for the purpose so that I don't get bail. 409, if the Honorable Court has, I am not reading the section, but I doesn't come in the definition of a public servant or bank or an agent. So 409, there is no ingredient or evidence to again frame charge for 409. Now for 120B, that is a conspiracy. Now the Honorable Court is aware about the ingredient that for the charge of conspiracy, there has to be a meeting of mind. Just by alleging that I am a co-conspirator, it will not bear to even frame a charge. They have to show that there are some CDR records, there are some documents to show that I actually participate in the offense of the alleged transaction, and this is how I am a co-conspirator. Because for the charge of co-conspirator, it will be framed as far as the main accused. I will be also, since I am a I will be charged as same as of the main accused who has committed the offense. But the linkage has to be established by the prosecution. Just merely saying I am a co-conspirator, that will not suffice. And as far as Section 3 of GPID Act is concerned, the nature of transaction is of deposit. But to show the effect that even the company is not a financial establishment, but I am not making quar to the company. As far as my role is concerned, I have not been involved in any transaction with regard to any signature, or a money has to come with me. Therefore, the charge for GPID will also not be applicable. Now, stricto sensu, that is what why when I open my submission, I made a submission on two facets. Now, as far as discharge is concerned, there are two things which the Honorable Court may consider it. One is suspicion and one is grave suspicion. Now, if there is a suspicion also in the then the Honorable Court may tilt in favor of the accused. Now, with this documents and with this evidence which I made submission, how a charge would be framed and how I will be put to trial without any documentary evidence, without any signature, without any beneficiary of the alleged amount have been received by me. I am not involved in the management of the company since inception. Just since I was a wife of the main accused at the relevant point of time, my matrimonial disputes were also pending. I have been arraigned as an accused. I was the first person who was arrested. And then multiple FIR has been registered for the same transaction. Now, this also amounts to a double jeopardy because for the same transaction, only witness has to be counted in the main offense. Multiple FIR has been registered for the same transaction, same company, same accused. So when my submission with regard to the framing of charge, that when there is no documentary evidence, there is a blanket false averment has been made in the charge sheet showing that just to prejudice that I am a promoter or a director somewhere, prosecution is even not sure that what is the role in to be prescribed in my entire alleged transaction. If a lawsuit may see the charge sheet, my role is not defined. That how I am benefited. Because for committing a financial fraud case, there has to be some benefit, there has to be some abatement. Nothing has to be proved. If I read the entire charge sheet as it is.
Yes.
Now, even this submission, how my role is prescribed. When I'm just making one more submission apart from these facts. At the time of my bail application, since there was no role, the prosecution come with a reply that there is one my photograph is there with main accused. That is what that was the story. But that is also not part of the charge sheet. That is nowhere even in the reply of the charge sheet. Even there has been stated that how I am connected with it. So in light of this background, some judgments in the Honorable Court may permit. May I just enter the list of judgments? Now, only one judgment. Now, if a honorable court may have my compilation, there are first three judgments are there, which is of D. Rajkumar, Aruna, and Prasanna Devi. Now, these three judgments are of Madras High Court. All three judgments are case of a discharge. And before I take to the relevant paragraph, this all three cases was having a similar facts to my case, wherein a wife was roped and where a husband was the main accused. Similar, entire similarly facts. And I was discharged. Now, please see if one of the judgment, third judgment of Prasanna Devi is very important. Only two para which I just want to highlight to the Honorable Court. If a Honorable Court may see para 13. May I read? The facts remains that the petitioner was not a partner of the partnership
1
firm.
minute.
Cha-
13, para 13 of first judgment.
Prasanna Devi, third judgment. First two also on the similar facts, but more relevant to my facts, similar facts, is third judgment. Prasanna Devi
Yes.
was that judgment the Honorable Court may come to internal page number 4, para 13.
Yes.
May I read? Now the facts remains that the petitioner was not a partner of the partnership firm charged in this case under section 5 of the TN-PID Act. The only allegation leveled by the witness is examined on the side of the prosecuting agency is that the petitioner canvassed for deposits for the financial institution. Very similar case to my case. The witness have said that I was the wife. Now I read further. To invoke the penal provision under Section 5 of the TNPID Act, one should shoulder the responsibility of managing the affairs of the financial firm or company. I find that the provision under Section 5 of the TNPID Act has been drafted very carefully. A person who merely manages the affairs of a firm or a company, that is clerk, accountant, office assistants, who are just paid servants, would not be responsible for the management, in the sense that they are not answerable to the claim made against the financial firm. In other words, a person who simply manages the affairs of the firm cannot be said to have taken the responsibility of answering the allegation of mismanagement of the affairs of the firm. The clerk, accountant, and office assistant come under the said category. They have been given a role to manage the affairs of the partnership firm, but they are not responsible for the mismanagement of the firm when the same is under challenge by the third party. All the person who manage the affairs of the financial institution need not necessarily be responsible for the management of the affairs of the institution. What is required under Section 5 of the TNPID Act, now Section 5 is similar to Section 3 of the GPID Act, is that the person charged should have been responsible for managing the affairs of the institution. The person who simply manages the affairs of the financial institution as paid servant fall out of the ambit of the scope of the provision of law. Now please come to para 14. The canvassing agents. May I read for para 14? May I read, sir? Yes.
Yes.
Para 14. Para 14, 15, and 16 is very important. Similar to my facts, the canvassing agent as such cannot be held responsible for the management of the affairs of the firm. A canvassing agent may contribute his might by mobilizing funds for the financial firm on contract basis for payment of brokerage or service charges. By no stretch of imagination we can say that such a person shoulders the responsibility of the management of the affairs of the firm. A canvassing agent gives a rosy picture about the firm to mobilize the deposit. It is only the depositors who shall verify the veracity of such embellished version regarding the performance of a firm and the financial soundness, therefore, with the person who is responsible for the management of firm and offer his deposit. Now, para 15. Sometimes all family members who have nothing to do with the financial bungling of the institution are roped in on the mere allegation that they started canvassing for deposit for the financial. So this is very similar to my case. The only allegation which is canvassed that I was there with the main accused.
You have that Tamil Nadu's section 5.
Yes. I have a bare act which I just
You can section 5 copy. To compare whether it is peri materia.
it is I'll just
No, then we'll have to go through that.
yes, I'll just
Whether it is peri materia or different something.
it is exact peri materia. It is because Tamil Nadu was the first state to launch this to enact this establishment.
Tamil Nadu was the first.
First state. And thereafter, this subsequent state came with this enactment. I'll just tender the salt.
You can just provide it.
I'll just provide
Yes, other judgments for what?
yes. So just concluding one submission for these three judgments, that as far as my role as a family member, assuming that I'm a family member, assuming that I was there for canvassing,
Then also you would not be.
then also considering this this para which I just read out, that just being a family member, just because if I am canvassing, assuming even I am in employment for the firm, then for the mismanagement or the offense committed by a firm, I cannot shoulder the responsibility on myself. As far as my case, I am on a better footing compared to this judgment, that I am not involved in the management. That is what I stressed to the point my first submission, that the offense is committed by a corporate body and person who are managing it. This is how the offense has been perpetuated. And therefore, I come on the third limb of argument or on the hierarchy, where just I am a family member of the main accused who was managing the affairs of the company, who perpetuated this offense. So that is why I am structuring my argument that first comes the company, that comes the governing board of directors who management the company, and third, as far as my client is concerned, I am on a third limb of hierarchy where I am a family member. So even assuming that my presence is shown, suppose, since even there is no record to show that I have canvassed.
Yes, I have confirmed.
Yes. Now, one more judgment I just want to, fourth judgment of Sunil Bharti Mittal versus CBI. Now, this is a very landmark judgment of the Honorable Supreme Court, and it is structured on the principle of alter ego. That in case of a company, what is the position, and in case of a individual capacity, what is the position. Now, please see para 35. Internal page 18. Para 35, 36 and 37. Now, before I take the relevant paragraph, I just want to give a brief, just in 2 lines, what was the facts of this case. In this case, this was a very famous case of allotment of, there was a corruption in the 2G scam. Yes, very famous. Now, what has happened, that Sunil Bharti was summoned by the court to participate in the trial. Now, please see para 35. May I read para 35?
Yes.
It is an abundant clear from the above that the principle which is laid down to the effect that a criminal intent of the alter ego of the company, that is a personal group of persons that guide the business of the company, would be imputed to the company corporation. The legal proposition that is laid down in the aforesaid judgment, that if the person or group of person who controls the affairs of the company commit an offense with a criminal intent, their criminality can be imputed to the company as well as their alter ego of the company. So here para 35 says that if a directors who have committed an offense, since they are alter ego of the company, company is also liable to be prosecuted for the act of the directors. Para 36. In the present case, however, this principle is applied exactly reverse scenario. Here company is the accused person and the special magistrate has observed in the impugned order that since the appellants representing the direct mind and will of each company, their state of mind is the state of mind of the company, and therefore on this premise, acts of the company is attributed and imputed to the appellants. It is difficult to accept as the correct principle of law as demonstrated herein after this proposition would run contrary to the principle of vicarious liability, detailing the circumstances under which a direction of company can be held liable. Sorry, here in this case, what happened? The company was arraigned as an accused, not the directors. Therefore, the court summons the director, saying that since you represent the company, you are the shadow of the company. So for the company who has committed an offense, you are liable to be prosecuted.
Now, in this case, it is once again reverse.
Reverse.
Yes.
But on a better footing that I am not even a director. Why, sir, I am structuring my argument based on the company, because here the main perpetuated offender is a company based on which the entire transaction has been carried out. There is no individual transaction with one-to-one person. That is what my, now, if I read further, circumstances when director,
Take care of your judgment.
pardon?
I will go through your.
Yes, so para 36 and 37 is important. No. And there is last judgment of the Supreme Court.
It is with regard to 406, 420.
406 or 420. So now even there are I have not
There is the recent one judgment where the state is directed to circulate their judgment also, but they are not doing it. In every DGP of the entire.
Notwithstanding anything contained in chapter 2 where any financial establishment defaults the return of the deposit or defaults the payment of interest on the deposit or fails to return in any kind or fails to render service for which deposit has been made, every person responsible for the management of the affairs of the financial establishment shall be punished with imprisonment for a term which may extend to 10 years or with fine which may extend to 1 lakh rupees, or such financial establishment is also liable for fine which may extend to 1 lakh rupees, so and so. So now why I am here submitting for the financial establishment? Because the prosecution also has to show that I fall under the ambit of financial establishment. So even company can also be prosecuted. Now how the company will prosecuted? I will be penalized for the alleged offense. So section 5, now if I read the section 3 of the GPID Act, may I read section 3? Fraudulent defaults by financial establishment. Any financial establishment with which fraudulently defaults any repayment of deposit on maturity along with any benefit in the form of interest, bonus, profit, or in any other form as promised, or fraudulent fails to render service as assured against the deposit, every person including the promoter, partner, director, manager, or any other person or an employee responsible for the management of conducting of the business or affairs of such financial establishment shall on conviction be punished with imprisonment for a term which may extend to 6 years. So here it is 6 years, there it is 10 years. But the definition and the verbate is exact verbatim.
Yes.
So in light of these facts, when my role is not prescribed, when there is no even evidence to show that under all this section which is alleged, where the charge would be framed, why I should be put to trial? This is my urge before this honorable court. In light of this, my application may be considered by this honorable court.
Both same argument,
Same argument for all the three. Same transaction, all the three.
same transaction. with
Same
both
transaction,
different
same
parties.
accused, same company.
Chalo. પેલી 420 નહીં લાગુ પડે. હમ. Yes. એમના સ્ટેટમેન્ટમાં શું કહે છે આમનો rule? હા.
એક સાહેબ આપી દુસરાનું ઈસાભાઈ ભોગારીનું નિવેદન છે ધંધો વકીલાત ઓલા બે એડવોકેટ એક વેપારી છે 9 નંબર મારી 11 પોર્શન એવો છે પેજ નંબર 182 પર એમનું નિવેદન ચાર્જશીટ
એક મિનિટ આવો તો 110. 182 નંબરનું પાનું. બધામાં આ જ રીતે છે.
હા સર 9 જણા છે 9 કે 10 એ નિવેદનો મુજબ છે હાલના અરજદાર આરોપી બેન મુખ્ય આરોપીના પત્ની નેહા ભંડારી એમના પિતા વિરેન્દ્ર ભંડારી અવારનવાર મેટ્રો કોર્ટ ખાતે જતા હતા અને સ્કીમો સંભાળતા.
Yes.
રિપીટ કરતો નથી બધા પ્રમોટર્સ તરીકે જતા હતા સ્કીમ સમજાવતા હતા section 3
તો promoter નો evidence નથી, promoter નો evidence નથી.
promoter નો evidence નથી પણ એ ના પતિ સાથે ના સસરા સાથે મેટ્રો કોર્ટમાં જતા હતા અને સ્કીમ આખી સમજાવે આ રીતની સ્કીમ છે એ રીતે ત્રણેય જણે પૈસા લીધેલા 120 બી જોડે છે and section 3 માં any establishment is the prudent default take any repayment of the deposit on maturity along with person one again deposit every person including the promoters, partners, director, manager or any other person or employee responsible for the management or conducting of the business or the affairs of the such financial establishment. અચ્છા તમિલનાડુની સેક્શન 5 જે કહી છે એની અધર પર્સન તો છે પણ એ સાહેબ સેક્શન 3 ની જેવું નથી થાય આટલું ભાઈ અને સેક્શન 5 એમાં કમ્પાઉન્ડિંગ ઓફેન્સ અહીંયા એ વસ્તુ નથી
Section 5 માં
ભાઈ એ છે ને કમ્પાઉન્ડિંગ ઓફેન્સ છે કમ્પાઉન્ડિંગ પ્રોવિઝન છે ગુજરાતમાં નથી Also, not with any same content in the chapter second, where any financial establishment default the return of the deposit or default the payment of the interest of on deposit or fail to return any kind or fail to return service for which deposit has been made, every person responsible for the management of the affairs of the financial establishment shall punish. Our specific very deep વસ્તુ છે અને મદ્રાસ હાઈકોર્ટનું જજમેન્ટ છે સર એમાં એવું છે કે આરોપી એમ્પ્લોયી ને બધું નથી આવતું આપણા કાયદામાં એમ્પ્લોયી મેનેજર ડાયરેક્ટર પાર્ટનર difference મદ્રાસ હાઈકોર્ટના જજમેન્ટ અહીંયા સર ધ્યાને લઈ શકાય એવું નથી રૂલ આટલો સાહેબ એમનો જે મારી પાસે નિવેદન છે મૂકી કરી નાખી એમાં એમનું નામ
Sir, two submissions ખાલી એક last So my learned senior friend has just made that I am a promoter. Now, as per section 2, subsection 69 of the Companies Act, who is a promoter? Who is a founder of the company? So in the annual return in the prospectus, so since I am not a promoter, just there is a statement. Now there is a second submission from my learned friend that the definition of section 3 in GPID is more vast. Now the judgment which I cited of Madras High Court does not say that person who are in the employment is absolved from the liability. That is not the contention. But the honorable court says in that judgment that to shoulder the responsibility in the affairs, there has to be some material. It is not saying that blanketly that even the persons who are in the management or the employees are absoluted. That is not the contention. I have read the entire paragraph. They say that the responsibility is more higher on the pedestal to show that how I am involved. Just since I am canvassing or my appearance is shown with some other accused would not sufficient enough to say that I am involved in the affairs of the financial establishment of the company and committed an offense. That is what the criteria. So even in under section 5 of the TPID Act also, it is not say that I am absolute. And compounding of offense means that it is that if you pay the entire amount, the offense would be compounded. So that will not affect the, because the gravity section, there 10 years, here it is 6 years.
6 years.
May I give the
6 years.
6 years, there is a 10 years basically. Greatly obliged.
Mr. M.V. Sakaria is a small businessman, actually, Your Honor. When around approximately 2 to 3 months have been passed, a call has been made. I'm telling the version of MV Sakaria before the Honorable Court. According to MV Sakaria, a call has been received on his phone in which the fact has been communicated that come to collector's office and meet him. Subsequently, the remaining amount of rupees 1 lakh has been demanded by accused 1, A1. The demand has been placed, and after that, after the fact, when the demand have been made, Mr. Sakaria has due to certain business requirements, sir, visited Vadodara. He has been communicated that still your payment has not been made. When he has received that call, after that, he has called his son, Mr. Batuk Bhai, and he has directed that go and deposit the particular amount of rupees 98,000 which was remaining on that day. Batuk Bhai, along with his friend, goes to, Your Honor, I would like to mention here the branch, Vadwan branch, Bank of Baroda, Surendranagar. On 6th September 2019 and 7th September 2019, and has deposited an amount of 49,000 in 2 times. It has happened due to absence of PAN card because he was not having the PAN card at the same time. The amount has been deposited in an account number which have been provided by accused A1. The account number of that Bank of Baroda branch was 0637020000585, which was belonging to sir. ओके सर सर, तो बहुत एकदम सामान्य शब्दों में मैं बताना चाह रहा हूं आपको कि इन्होंने इस अकाउंट में, पर्टिकुलर अकाउंट में पैसे जमा करने के लिए बोला। वहां पर उन पर्टिकुलर तारीख को, जो 6 तारीख थी और 7वीं तारीख थी 9वें महीने की, साल था 2019, इन्होंने पैसे जमा कर दिए सर। इसके बाद में फैक्ट भी कम्युनिकेट कर दिया गया कलेक्टर साहब को कि आपके यहाँ पैसे जमा हो गए सर। अब क्या हुआ इसके बाद में सर? सर प्लीज, मैं बहुत ज्यादा मैंने तैयार किया है सर, हालांकि इंग्लिश में, लेकिन मैं बहुत ज्यादा कंफर्टेबल एक्चुअली फर्स्ट टाइम है सर, और कॉन्फिडेंट भी नहीं फील कर पा रहा हूँ आपकी कोर्ट के सामने सर, इस वजह से सर नहीं सर। यहाँ पे हुआ ये था, amount has been yes sir, and subsequently the amount of 98,000, yes sir, 98,000 in account, yes sir, yes sir, issued, license has been issued. After some time sir, due to certain reasons, his license has been cancelled. Sir, I would like to mention here the statement of PW1 here. Sir? Yes, sir, केवल उतना ही सर. यस सर, यस सर. उन्होंने बताया सर, मैं पैरा भी आपको अभी बता दे रहा हूं. उन्होंने बोला कि इसके रिगार्डिंग जब उनका लाइसेंस कैंसिल हो गया, उन्होंने सेवरल कंप्लेंट्स की सेवरल अथॉरिटीज को और इवन पीएमओ तक को उन्होंने शिकायत की सर इस फैक्ट की कि हमसे इस तरीके से ब्राइब मांगा गया और ब्राइब लिया गया. ये फैक्ट उन्होंने बोला. सब्सिक्वेंटली हम सर क्रोनोलॉजिकली, जैसा कि डिफेंस हमारे जो एडवोकेट थे उन्होंने भी बताया कई सारी बहुत सारी डेट्स के बारे में. सर यहाँ पे मैं कुछ डेट्स को मेंशन करना चाहता हूं जो 6 तारीख, 7 तारीख, 9वां महीना साल 2019 का था जब ये पैसा जमा किया गया. इसके बाद में 16 फरवरी साल 2021 को इन्होंने शिकायत की डायरेक्टर जो एसीबी अहमदाबाद के थे इनके समक्ष की इस तरीके से हमसे पैसा मांगा गया और इस तरीके से हमने पैसे जमा किए. इसके सब्सटेंटिएट करने के लिए सर इनकी जो एलिगेशंस थे इन्होंने बुलाया. तारीख थी 23 और 27 फरवरी साल 2021. बुलाया गया कंप्लेनेंट को और ये पता चला कि हाँ वास्तव में ऐसी ऐसी बातें हुई हैं. तो इन्होंने एक लेटर लिखा बैंक ऑफ बड़ौदा जो ब्रांच जहां पे इनका अकाउंट था, तो जनरल मैनेजर को इन्होंने बैंक ऑफ बड़ौदा के एसीबी ने लिखा एक लेटर कि क्या ये इस तरीके का कोई अमाउंट जमा किया गया है. 2 तारीख को सर वो रिसीव हो जाता है, 2 मार्च साल 2021 को ये प्राप्त होता है सर एसीबी को, जिसमें ये बात पता चलती है कि हाँ इस तरीके का डिपोजिशन हुआ था अमाउंट का सर. ये बात अब इसके बाद में सर इन्वेस्टिगेशन इनका चलता रहता है. इसी बीच में सर जो एसीबी थी उसको बहुत सारी मोर देन 39 कंप्लेंट्स मिली इन्हीं की, जो हमारे एक्यूज्ड वन है A1. इन सारे को इन्होंने अक्टूबर महीना और दिसंबर महीना इन सारे को गवर्नमेंट को फॉरवर्ड किया और एडिशनल चीफ सेक्रेटरी साहब थे इन्होंने इसको सीबीआई डीओपीटी को, डिपार्टमेंट ऑफ पर्सनल एंड ट्रेनिंग मिनिस्ट्री को सर भेज दिया. वहां से रिकमेंडेशन आया सर और नई दिल्ली सीबीआई नई दिल्ली की जो इकोनॉमिक ऑफेंसेस ब्रांच है 3rd, उसने सर एक प्रिलिमिनरी इन्वेस्टिगेशन स्टार्ट किया. उसमें पाया गया सर कि इस तरीके के जो एलिगेशंस थे ये ट्रू थे. अब उन्होंने रेकमेंड किया सर इनके अगेंस्ट केस इंस्टीट्यूट किया जाए, केस जो है रजिस्टर किया जाए. इस फर्दरेंस में सर 28/5 साल 2022 को इतना सारा सर ये जो समय लगा इसी वजह से लगा चूंकि एक बहुत लंबी प्रोसेस चल रही थी. इसके पीछे प्रिलिमिनरी इंक्वायरी भी चली सर, गवर्नमेंट ने भी कंफर्म किया. इसके बाद में ये किया गया सर, केस रजिस्टर किया गया. दिनांक सर मैं डेट देख करके जस्ट आपको बता रहा हूं, 18/5 साल 2022. और सर बहुत ही जल्दी मात्र 2 महीने के अंदर 18/7/2022 को सीबीआई इकोनॉमिक ऑफेंसेस ब्रांच ने इस केस में चार्जशीट भी सबमिट की ड्यू टू सर्टेन रीजंस. कुछ रीजंस थे सर. ये जो केस रजिस्टर किया गया सर, यहां पर जो मेन एलिगेशंस थे वो थे सर, इन्होंने कुल 271 आर्म्स लाइसेंस इशू किए जिसमें जो पुलिस विभाग था इसकी निगेटिव रिपोर्ट थी. एसपी साहब की निगेटिव रिपोर्ट प्राप्त होने के बावजूद 39 लाइसेंसेस इन्होंने इशू किए. ये एक्यूज्ड वन की बात है, हु वाज देन कलेक्टर ऑफ दैट प्लेस. अदर देन दिस सर देयर वर 3 अदर एलिगेशंस. व्हाट वर दोस सर? डिमांड एंड एक्सेप्टेंस फॉर अलॉटमेंट ऑफ प्लॉट्स टू इनएलिजिबल पर्संस. जो एलिजिबल नहीं थे उनको प्लॉट्स दिए गए. इसके अलावा अदर देन दिस एक्सेप्टेंस ऑफ ग्रेटिफिकेशन फॉर रेगुलराइजेशन ऑफ इलीगल पोजीशन, किन्हीं के पास में पोजीशन था उसको रेगुलराइज कर दिया गया, इस ये भी एक हेड है जो केस रजिस्टर किया गया है उसमें। अदर देन दिस सर परचेज ऑफ शॉप्स एट वेरी बिलो लेवल, मार्केट जो लेवल था, मार्केट जो प्राइस था उसका, उसके बहुत बिलो जा करके और ये परचेज किया गया अराउंड 47 लाख रुपए में सर। तो ये कुछ एलिगेशंस थे जिसमें सर इन्वेस्टिगेट किया सीबीआई ईओबी इकोनॉमिक ऑफेंसेस ब्रांच ने और ये चार्जशीट सबमिट की सर। इन्वेस्टिगेशन के दौरान सर कुछ फैक्ट्स पता चले, वो फैक्ट्स थे सर कि ये जो फैक्ट्स में ये सबसे पहले कंफर्म किया गया कि ये जो अकाउंट है जिसमें पैसे डाले गए हैं वो कौन व्यक्ति है, और यहां से पिक्चर में आता है सर A2 मेनन साहब। ये कंफर्म हुआ कि ये अकाउंट है, उन्हीं का अकाउंट है सर। ये भी पता चला कि इनके अकाउंट में पैसे डाले गए हैं। अब इसके बाद इनकी छानबीन होनी शुरू हुई, तो ये पता चला जब पूछा गया इनसे कि क्यों ये पैसे डाले गए, तो इसको कोरोबरेट करने के लिए सर इन्होंने कुछ रिसीप्ट्स बनाई हुई थी। देयर वाज सम रिसीप्ट्स बिकॉज ही वाज द प्रोप्राइटर ऑफ जींस कॉर्नर, मेसर्स जींस कॉर्नर, ही वाज डीलिंग विद क्लोथ्स एक्चुअली। तो सर जब इनका इन्वेस्टिगेशन किया गया तो इनकी जो बिलिंग मशीन थी वहां पर फोर्ज्ड रिसिप्ट्स मिली। मिस्टर एमवी सर 39 prosecution witnesses as well 45 relied upon documents. Yes sir. While looking towards important prosecution witnesses as well their statements, sir, I am going through the gist of their statements. Sir, my first and most important witness, who is complainant himself, Shri Mathur Bhai M.V. Sakaria. While looking towards the statement given by Mr. M.V. Sakaria, he says what it provides, that there is an oral evidence of Mr. M.V. Sakaria who will prove that the accused K. Rajesh has demanded bribe of rupees 5 lakh from him at his office for issuance of arm license during April 2019. Post negotiating, the bribe amount was settled to rupees 4 lakh, and afterwards it has been given by his son, who was accompanied with his friend. Subsequently, sir, there is oral evidence of Mr. Batuk Bhai Mathur, who is PW2. His No, sir, I am not going to the. Okay, sir. Yes, sir. बिल्कुल सर, मैं करता हूँ। जस्ट मैं जाने वाला था सर, पहले इसको रिसाइड करके इसके बाद में फिर मैं आगे बढ़ने वाला था। कोई दिक्कत नहीं सर, मैंने रिटर्न रिप्लाई फाइल किया हुआ है सर। हमारे पास में सर जो डायरेक्ट चीजें आ रही हैं, पहली चीज डिमांड और दूसरी चीज उसका एक्सेप्टेंस। इसके रिगार्डिंग में सर आपको बताना चाह रहा हूं, एक नया कॉन्सेप्ट डिफेंस ने इधर इमर्ज किया हुआ था सर, पोस्ट पेड ब्राइब का। सर मैं चार्जशीट सॉरी सर, मैं विटनेस के स्टेटमेंट्स में मिस्टर एमवी सकारिया का जो स्टेटमेंट है सर, वहां पे एमवी सकारिया का जो स्टेटमेंट है, एक सेकंड में जस्ट आपको बता रहा हूं सर पॉइंट आउट करके। इनके स्टेटमेंट में इन्होंने कहा है कि ऑफिस जाने के बाद उन्होंने कहा जो बचा हुआ अमाउंट है 1/3 अमाउंट ऑलरेडी, 2/3 जो है वो पेमेंट हो चुका है, 3 लाख पेमेंट हो चुका है, जो रिमेनिंग अमाउंट है, तो ये जो टर्म रिमेनिंग यूज किया गया है सर, ये कंटिन्यूटी में यूज किया गया है, ना कि पार्ट में, कि पता लगा पहले सेटलमेंट हुआ था 3 लाख का, उसके बाद में बात करने लगे, हम चर्चा करने लगे कि 1 लाख अब बाद में और देंगे आप, वो सेपरेट नहीं है सर, वो पहले से ही जुड़ा हुआ है, रिमेनिंग पार्ट है। दैट्स वाई द फैक्ट ऑफ पोस्ट पेड ब्राइब इज क्वाइट इरेलीवेंट, बेसलेस है सर। ये केवल और केवल प्रोसिक्यूशन की स्टोरी को डेविएट करने की कोशिश की जा रही है। दूसरी चीज सर, जो फैक्ट असर्ट किया गया कि जो कंप्लेनेंट है इट सेल्फ रॉन्ग डूअर है सर। एक तरफ हम देख रहे हैं कि पावरफुल आईएएस अधिकारी है जो कि उस जिले का कलेक्टर है जहां पर वो कॉमन बिजनेसमैन रिजाइड कर रहा है। फैक्ट इमर्ज किया गया, फैक्ट लाया गया कोर्ट के सामने, माननीय न्यायालय के सामने, कि इतनी डिलेड कंप्लेंट है, इतनी डिलेड कंप्लेंट है, और ये जो डिलेड कंप्लेंट है इट सेल्फ मैलाफाइड इंटेंशन को शो कर रही है। ये फैक्ट असर्ट किया गया। हमने यहां पर अभी लास्ट टाइम भी जब प्रोसिक्यूशन वर्जन में पढ़ रहा था, यहां पर इनका स्टेटमेंट पढ़ रहा था, यहां पर ये फैक्ट पीडब्ल्यू के स्टेटमेंट इटसेल्फ में है सर। पैरा नंबर शायद 17 है, पैरा नंबर 17 का की पहली लाइन है सर, ऑन बीइंग आस्क्ड आई स्टेट दैट आई हैव गिवन सेवरल कंप्लेंट्स टू वेरियस अथॉरिटीज इंक्लूडिंग पीएमओ ऑफिस फॉर टेकिंग लीगल एक्शन अगेंस्ट श्री के राजेश। और इसके बाद ये करने के बाद इन्होंने कहा कि हमने बहुत सारी कंप्लेंट्स की बावजूद इसके कोई एक्शन नहीं हुआ सर। ये इटसेल्फ शो करता है सर सीरियसनेस को जो इस केस की है। जब बहुत सारी कंप्लेंट जो है वो इकट्ठा हो गए, उसके बाद में सर एसीबी ने डायरेक्ट फॉरवर्ड किया गवर्नमेंट को, गवर्नमेंट ने इटसेल्फ फॉरवर्ड किया मिनिस्ट्री को, मिनिस्ट्री ने फॉरवर्ड किया फिर सीबीआई को, और तब सर इन्वेस्टिगेशन में ये एक फैक्ट आया है निकल करके, इस जो अलेज्ड ब्राइबरी डिमांड एंड एक्सेप्टेंस वाला केस है सर। यस सर। सर, सर डेफिनेटली सर, फर्स्टली सर, तीन, सर, सर मैं कुछ फैक्ट्स रखना चाह रहा हूं सर। यस सर। इसके, यस सर, यस सर, हम्म, Yes, sir. Demand. Yes, sir. Yes, sir. Yes, sir. Okay, sir. Then I am not going to reply that fact particularly, sir. Yes, sir. Because we are looking into the discharge petition actually of which has been filed by Mr. K. Rajesh. We are required to go through the allegations which has been made, whether the facts exists or not. उनको अभियुक्त बनाया गया नहीं बनाया गया ये दूसरा मसला है सर। यहां पर मसला सबसे पहला यही आ रहा है कि राजेश जी के ऊपर जो एलिगेशंस है उसके अगेंस्ट एविडेंस एग्जिस्टेंस में है या नहीं। सेक्शन 59 ऑफ एविडेंस एक्ट से इटसेल्फ बताता है कि कोई भी फैक्ट, सारे के सारे फैक्ट्स अदर देन द इनर कंटेंट ऑफ द डॉक्यूमेंट एज वेल इलेक्ट्रॉनिक रिकॉर्ड्स वो प्रूव किए जा सकते हैं सर ओरल एविडेंस के द्वारा। यहां पर जो हुआ है, जो इंसिडेंट है, ऐसे इंसिडेंट यूजुअली सर मार्केट्स में नहीं होते, सेक्लूडेड प्लेसेस में होते हैं सर। वहां पर वो व्यक्ति जो इसका हिस्सेदार बन रहा है, जिससे इस तरीके की मांग की जा रही है, जिसको दिया जा रहा है, केवल और केवल यही दो विटनेसेस हो सकते हैं जो बेहतर तरीके से होल इंसिडेंट के बारे में, होल एपिसोड के बारे में बता सकते हैं। यहां पर ओरल एविडेंस के माध्यम से प्रोसिक्यूशन इस बात को इस्टेब्लिश करता है सर कि हमसे डिमांड की गई थी और हमने जो बताया गया पैसा है वो हमने सबमिट किया है। अदर देन दिस सर यस सर, कैश में दिया। एंड इस फैक्ट को, यस सर, ओरल सबमिशन ऑफ मिस्टर एमवी सकारिया सर, 98,000 सर। सर अब इसके रिगार्डिंग सर हम सेक्शन 8 एविडेंस एक्ट का मेंशन करना चाह रहे हैं सर। वहां पर जो कंडक्ट है आइदर प्रीवियस और सब्सिक्वेंट, उसको इंपॉर्टेंट बनाया गया है सर, रेलिवेंट बनाया गया सर। ये फैक्ट कंसिडरेबल सर। हमने आपको कुछ डेट्स बताई हुई थी सर। 16 तारीख को ये कंप्लेंट देते हैं, शिकायत करते हैं एसीबी के पास में। 23 तारीख और 26 तारीख को फरवरी महीने में ही 2021 में एसीबी जो है बुलाती है इनके जो एलिगेशन ये लगा रहे हैं उसकी जेन्यूननेस को चेक करने के लिए से इनका स्टेटमेंट लेने, वो रिकॉर्ड करते हैं सर। और पहली तारीख को बैंक ऑफ बड़ौदा के जीएम को एक लेटर लिखते हैं सर कि क्या आपके यहाँ इस तरीके का पैसा जमा हुआ। चार्जशीट में सर मैं जस्ट आपको पन्ना बता रहा हूँ, पेज बता रहा हूँ जस्ट सर। चार्जशीट के पेज नंबर 8 पे और 9 पे, 8 और 9, यहाँ पे डेट बहुत रेलिवेंट है सर, कंसिडरेबल है और इनका कंडक्ट इटसेल्फ बिकम्स वेरी इंपॉर्टेंट सर। यहां पर क्या होता है सर, एविडेंसेस को बनाने के लिए, दिखाने के लिए सर, पहली तारीख को बैंक ऑफ बड़ौदा में लेटर पहुंचा है, 2 तारीख को रिप्लाई आया है उनका, 3 तारीख को मैं आपको पढ़ करके बता रहा हूं सर, 3/3/2021 17:23 से लेकर के और इसके बाद 1/4/2021 17:16 तक 9 बार, 8 बार, 7 बार उन इनवाइसेस को जिनको फाइनली डिफेंस प्रेजेंट कर रहा है किसके नाम से, मथुर सकारिया, जिन्होंने जींस कॉर्नर के नाम वो पैसे जमा किए हुए थे। जो जींस कॉर्नर है वो शो कर रहा है कि इन्होंने पैसे जमा किए थे और इन्होंने माल खरीद लिया, जबकि ये रिसिप्ट जो है वो ओरिजिनली जनरेट की गई थी 30/8/2019। ये वही साल है, ये लगभग वही महीना है जब ये पेमेंट किया गया था। और ये जो इनवाइसेस जो बाद में फैब्रिकेट की गई हैं, फोर्ज की गई हैं सर, ये ओरिजिनली किनके नाम इश्यूड थी, ये भी बात आई है। हमारा जो विटनेस है, अभी मैं नाम और सारी चीजें बता रहा हूं सर। ये इनवाइसेस जो जनरेट की गई थी ये ओरिजिनली सर किनके नाम थी, प्रफुल्ल भाई, परेश भाई, इनके नाम से 20,660, 17,620 और 12,380। और एक जो चौथी इनवाइस थी जिसको भी कन्वर्ट कर दिया गया किसके मत, एमवी सकारिया के नाम से, वो थी 49,000 रुपए की, उस सर के नाम से थी। इस पे कोई मोबाइल नंबर भी नहीं पड़ा। और जब इन लोगों को एग्जामिन किया गया, इन लोगों से पूछताछ की गई सर, तो ये फैक्ट पता चला कि इन लोगों ने ओरिजिनली सामान खरीदा हुआ था। ये इनकी ओरिजिनल इनवाइसेस थी, जिनको बाद में कन्वर्ट करके इनवाइस नंबर 992 है, इनवाइस नंबर 1007 1016 1023 इनको कन्वर्ट करके किसके नाम पहुंचा दिया गया, एमवी सकारिया के नाम। और ये जो होल इंसिडेंट, अभी ये मान लीजिए बाई चांस हम मान लेते हैं अगर, तो एक बार होगा सर। ये 30/8/2019 को जो इनवाइस जनरेट की गई थी, ये 3/3 को बदली गई, 26/3 को बदली गई, 1/4 को बदली गई, 1/4 को 6 बार बदली गई। ये इट सेल्फ कंडक्ट शो कर रहा है। और सर एक और बहुत इंपॉर्टेंट फैक्ट है जो क्वाइट रेलिवेंट है यहां पर। ये केस रजिस्टर हुआ है, जस्ट लेट मी सी सर, ये केस रजिस्टर हुआ है सर 18/5/2022 को। तो एक सेकेंड, 18/5/2022 को ये केस रजिस्टर हुआ है सर। और इसी से कुछ दिन पहले ही इन्होंने कॉल किया है मेसर्स जींस कॉर्नर को। जस्ट मैं आपको डेट बता रहा हूं सर। 11/5/2022 ये डेट थी, 11/5/2022। और 18 तारीख को मुकदमा दर्ज किया गया, एक 7 दिन पहले। और सर वो लेटर बैंक पहुंचने के जस्ट बाद, अभी हालांकि मैं अपने आईओ से खुद को कनेक्ट भी नहीं कर पा रहा हूँ, किसी सीक्रेट काम पर है सर, लेकिन ये पता चला है कि जब ये फोर्ज्ड रसीदें मिली हैं, उसी के साथ में वो बैंक का लेटर भी उनके यहां मिला हुआ है, जो मेसर्स जींस कॉर्नर है। बैंक का लेटर जैसे पहुंचा है सर, वैसे ही तुरंत अल्टरेशन शुरू। तो ये कंडक्ट इटसेल्फ बता रहा है। अगर वहां पे एक इलस्ट्रेशन है सर की, जो किसी गिल्ट में इन्वॉल्व रहता है, वो उसके कंडक्ट में दिखाई पड़ता है सर। इसके अलावा सर सेक्शन 114 एविडेंस एक्ट का, वो इटसेल्फ बता रहा है ये फर्निश ही नहीं कर पाए किसके रिगार्डिंग ये पैसा लिया गया था वहां पर। और सर इसके अलावा बहुत सारे फैक्ट्स हैं, जैसे इनके घर से वो जो जींस कॉर्नर था, उस जगह की दूरी 350 किलोमीटर इटसेल्फ है। ये खुद एक जिले में रह रहे थे, अगर इनको कपड़े ही खरीदने होते तो फिर वहां से खरीद लेते। मेसर्स जींस कॉर्नर से इनका दूर दूर तक पुराना नाता नहीं था। प्रोसिक्यूशन पूरी तरीके से इस फैक्ट को इस्टेब्लिश कर रहा है सर कि साल 2013 से सर मेसर्स जींस कॉर्नर नूर भाई को जानना है। इनके मोबाइल में जो नंबर सेव था, वो राज के नाम से मेसर्स जींस कॉर्नर वाले जो नूर भाई थे उनके मोबाइल में सेव था, नूर भाई के नाम से सर के मोबाइल में सेव था। कॉल कर रहे हैं सर 11 तारीख को, 11 तारीख 5वां महीना साल 2021। ये इटसेल्फ शो कर रहा है कि विधिवत जानना है, जानने पहचानने में कोई दिक्कत नहीं। इसके अलावा सर इनका जो सर का स्टेटमेंट है, वो इटसेल्फ शो कर रहा है कि आपकी जो खरीद फरोख्त है, वो वहां से हुई है इससे पहले। और डिफेंस इस फैक्ट को भी एडमिट कर रहा है ड्यूली कि हम पहले से जानना है। तो पहचान के रिगार्डिंग कोई फैक्ट हिडन नहीं है सर। ये जो फैक्ट है regarding acceptance of rupees 98,000 in account of Messrs Jeans Corner, which has been given in form of bribe by Mr. M.V. Sakaria, which has been deposited by his son. ये फैक्ट आता है नजर में। कंडक्ट इटसेल्फ सर रेलिवेंट बनाता है। जो निर्दोष होता है, जो इनोसेंट होता है, वो शेर की तरह खड़ा रहता है सर, और जो कहीं किसी गिल्ट में इन्वॉल्व होता है सर, वो भागता है सर। जी सर, तो यहां पर ये फैक्ट है सर। और सर जहां तक बात है इस फैक्ट की, कि यहां पर जो फैक्ट्स प्रेजेंट किए गए हैं प्रोसिक्यूशन की तरफ से, उनमें प्रोबेटिव वैल्यू क्या है, हम प्रूव कर पा रहे हैं कि नहीं। तो यहाँ पर बहुत सारे केसेस में सर इस तरीके से माननीय न्यायालय ने उच्चतम न्यायालय ने असर्ट किया है सर कि यहाँ पर मिनी ट्रायल नहीं हो रहा है, यहाँ पर इवेल्युएशन प्राइमा फेसाई केस बन रहा है या नहीं बन रहा है ये देखा जा रहा है, और माननीय न्यायालय के समक्ष जो है ये फैक्ट रखा जा चुका है। तो सर प्रोसिक्यूशन इसमें पूरी तरीके से अपने केस को इस्टेब्लिश करता है सर, कैपेबल है, और हमारे पास में डॉक्यूमेंट्री और ऑक्यूलर एविडेंस अवेलेबल है हमारे मामले में सर। तो इस वजह से सर इनकी जो डिस्चार्ज पिटीशन है रिजेक्ट की जाए सर और चार्जेस फ्रेम किए जाए, ये रिक्वेस्ट है सर हमारी।
हिसाब से પહેલું છે Correct.
सर ठीक है
सर रिसीव कॉपी कर दीजिए, ये आपका कॉपी है
सर।
Sir, with response to their submission, for factual metrics are concerned, dates are very much relevant for the honorable court to determine. I'll not repeat. I'll not repeat. In a nutshell, and for the perusal of the honorable court, I have prepared one small compilation along with the relevant portion of the documents as well. लो अपन ने जरा the concerned statements of the witnesses even. So it is undisputed that date for applying for arms license is 5/5/19. नहीं सर આપ્યું નથી મેં, ખાલી નામદાર કોર્ટને વર્બલ ઓથોરિટી આપી હતી. હાજી ફેક્ચ્યુઅલ મેટ્રિક્સ શું કશું જ નથી આપ્યું મેં. આમાં આખો હોલ કેસ સાહેબ એમનો જે છે કવર થઈ જશે. સો પોઈન્ટ નંબર 1 is concerned, page 1. Date of complaint is relevant 5/5/19. It is undisputed. સાહેબ એમનો જે ડોક્યુમેન્ટ છે D9 પાના નંબર 2 ઉપર છે એમનું. ચેક લિસ્ટ કરીને કાગળ છે સાહેબ મેં એની સાથે મૂકેલું છે. આવું એક ડોક્યુમેન્ટ છે સર, ચેક લિસ્ટ. Then, sir, the notes thereon is relevant. અરજદારને મુલાકાત માટે બોલાવીએ 10/6/19 તારીખ આપી સાહેબ, એને લગતા ડોક્યુમેન્ટ એમાં રજૂ થયા છે, સીબીઆઈએ રજૂ કરેલા છે, મારા નહીં. અને સાહેબ ઓર્ડર issuing the arms license is also dated 10/6/19, very same day. In between ક્યારે ડિમાન્ડ કરી હોય, that is not their case even. Where complaint is concerned, it is silent. હવે સાહેબ એમનું લાયસન્સ રદ કર્યું એવો એક ઇસ્યુ આવ્યો વચ્ચે. તેમનું લાયસન્સ જે રદ કર્યું, that date is relevant 11/9/20. એ લાયસન્સ રદ કરવા માટે સાહેબ સીબીઆઈએ રજૂ કરેલ દસ્તાવેજી પુરાવો D9 પાના નંબર 115.
અને એ પહેલા પાના નંબર 113 સાહેબ, સીબીઆઈ ના ડોક્યુમેન્ટ D9 નો પાના નંબર 113. સાહેબ, ઇટ ઇઝ ધ લેટર રિટન બાય ધ ભૂસ્તર શાસ્ત્રીની કચેરી. સાહેબ, આવા લેટર પેડ ઉપર છે આવું ડોક્યુમેન્ટ મેં મૂક્યું છે એવું બધું. હા સાહેબ. સો ઇટ વોઝ ધી રિટર્ન request from the concerned official Bhustar Shastri in writing. It is dated 7/9/20. That is also a relevant date for this honorable court, sir, and for all of us. હવે સાહેબ, એ લેટર જે છે it speaks in volume. મથુરભાઈ વાલજીભાઈ સાકરિયા એની જ વાત છે, બીજા કોઈની નહીં. કેરાળા વઢવાણ કોરેલીઝ આવેલી છે. સો ગેરકાયદેસર સાદી રેતી ખનિજ ખનન કરતા હોય અને ઈ પાસો દુરુપયોગ કરતા હોય પ્રસ્થાપિત થયેલ હોય 15/6/20 ના રોજ ક્રમાંક નંબર 100 થી 23,46,547 રૂપિયાનો દંડ વસૂલાતનો હુકમ કરેલો છે જીઓલોજીસ્ટ ડિપાર્ટમેન્ટે. વધુમાં નાના કેરાળા ખાતે કર્મચારી અધિકારીઓ પર હુમલાના બનાવ ભૂતકાળમાં બનેલ હોય, સદુર ઇસમ હથિયાર ગેરકાયદેસર ખનિજ ખનનમાં સંડોવાયેલા હોય, હથિયાર પરવાના બાબતે યોગ્ય કાર્યવાહી કરવા વિનંતી કરવામાં આવે છે. એન્ડ ધેન આફ્ટર સર પેજ 115 જિલ્લા મેજિસ્ટ્રેટની કચેરીનો સાહેબ આદેશ કે ભાઈ અમને ભૂસ્તર શાસ્ત્રીની આ તારીખનો પત્ર મળ્યો છે 7/9/20 નો. ઇન રિસ્પેક્ટ thereof your arms license is being revoked. Now, sir, you filed appeal against the impugned order, the order of revoking the arms license. He filed appeal before the Gru Sachiv. Sir, it is on page number D9, pana number D8, pana number 36. સીબીઆઈ આ પિટિશનની કોપી રજૂ કરી છે D8 પાના નંબર 36. ક્રમાંક રિવોલ્વર 100 અપીલ નંબર 100 મહેરબાન શ્રી ગૃહ સચિવ સાહેબ ગૃહ વિભાગ ગુજરાત સરકાર સચિવાલય ગાંધીનગર વિવાદી ઓબ્લિક અરજદાર મથુરભાઈ સાકરિયા વિરુદ્ધ શ્રી સરકાર પરવાના નંબર 100. Sir, it filed on 15/9/20. appeal memo na પાના નંબર 2 ઉપર તારીખ છે 15/9/20. Now in this appeal memo there is not a whisper why accused number 1 is concerned or his conduct is concerned કે સાહેબ મારી પાસે અત્યારના પૈસા લીધા ને મારું અત્યારનું લાયસન્સ રદ કર્યું. You see, if as alleged by the prosecution he might have definitely alleged against the concerned person, he can approach the Secretary Home Department against me, against my order. So there is silent. Then, sir, Mathur Sakaria is concerned, it is undisputed fact that it is their main and prime witness. Previous investigation was conducted by ACB Gujarat. So, sir, his 3 statements were previously recorded by the ACB Gujarat by Mr. J.R. Rajput. J.R. Jhala. I mean, sorry, J.R. Jhala. PI attached with the ACB. Sir, in each and every statement, he had tried to improvise his statement. અને એના માટે સાહેબ એક ટેબ્યુલર ફોર્મમાં એમની કઈ તારીખના સ્ટેટમેન્ટમાં એમના શું સ્ટેન્ડ રહ્યા અને ફરિયાદમાં શું રહ્યું. હા नहीं ये नहीं, आज जो मैंने दिया ना आपको उसके अंदर है. ક્યારેક સાહેબ લાંચની રકમ 3,98,000 થઈ, ક્યારેક 4,98,000 રૂપિયા થઈ. ક્યારેક એવું કે 1 લાખના 3 ટુકડામાં મેં રકમ ચૂકવી, મોડ ઓફ પેમેન્ટ. Try to give a contradictory version on each and every occasion, sir. કે સાહેબ 27 નંબરનો પોઈન્ટ પૂરો થાય ને એના પછી તરત જ સાહેબ ટેબ્યુલર ફોર્મમાં 4-5 પેજ આપેલા છે અમે કઈ તારીખના સ્ટેટમેન્ટમાં એમણે શું કીધું. આ સાહેબ એના જે કન્ટ્રાડિક્ટરી વર્ઝન છે ને એનું એનિમોસ્ટી ભરેલું સાહેબ એટીટ્યુડ છે જેને લઈને હાલની ફરિયાદ થઈ. ધેટ ઇઝ માય કન્ટેન્શન. ફોર ધીસ પર્પઝ સર આઈ રિલાય અપોન 2011 વોલ્યુમ 6 સુપ્રીમ કોર્ટ કેસીસ સાહેબ એ ચુકાદાની કોપી આમાં છે જ. ધ ફર્સ્ટ ઓથોરિટી સ્ટેટ ઓફ કેરલા વર્સેસ સીપી રાવ. Did not see effect on presumption of innocence of the accused. And sir, what is relevant? Para 3 થી 12 છે એમાં most relevant para 6 of that judgment. Apart from that, it is the case of the respondent. When the CW1 met him in a hotel room, the respondent shouted that some currency notes had been thrusted in his pocket by CW1. Such shouts of the respondent were heard by PW1 and 2. The evidence of PW1 and 2 were recorded by the trial court. The evidence of PW1 and 2 could not be in any way shaken by any manner of the cross-examination. PW3 had also given evidence of the previous enmity between the college authorities and the respondent, who had an occasion to file reports with the college authorities on the basis of so and so, so and so, so and so. So, due to animosity of cancellation of sir arms license against the complainant is concerned, he has given the complaint against me. And sir, there is documentary evidence produced by the CBI themselves કે સાહેબ આ જીઓલોજીસ્ટ છે એ બી કરપ્શનમાં પડેલો છે અને those allegations were also made only after geologists fined him for lakhs of rupees. જીઓલોજીસ્ટના ઓર્ડરની સામે પણ સાહેબ એમણે અપીલ કરી. એ અપીલની અંદર there is not a whisper of any demand or any bribe. Then sir, નહીં સાહેબ હું ખાલી પોઈન્ટ છે ને વિથ ડોક્યુમેન્ટ્સ નામદાર કોર્ટને ધ્યાન બતાવી દઈશ. આઈ નોટ ટેક મચ લોંગ ટાઈમ. હું બધું ડોક્યુમેન્ટ વાંચતો બી નથી સાહેબ નામદાર કોર્ટ સમક્ષ. આઈ વિલ નોટ સ્પોઇલ ધ ટાઈમ ઓફ ધીસ કોર્ટ સર. આઈ નો ઇટ વેરી વેલ ધી વેલ્યુ ઓફ ધ ટાઈમ. હવે સાહેબ એમની 16/21 ફરિયાદ છે. સીબીઆઈનું બી સાહેબ એડમિટેડ સ્ટેટમેન્ટ. આઈ ઓલ્સો એડમિટ કે 16/21 એમની ફરિયાદ છે. એ સાહેબ એફિડેવિટ વાળી ફરિયાદ છે, પાના નંબર 12 વાળી આવી. અને એના આધારે પીઆઈ મિસ્ટર ઝાલા હેડ રેકોર્ડેડ ધ સ્ટેટમેન્ટ. એ પણ સાહેબ મેં આની સાથે રજૂ કરેલા છે. D8માં એની અંદર આવે છે સાહેબ. 23/21 એમનું સ્ટેટમેન્ટ છે અને જેની અંદર સાહેબ એવું કહે છે કે 3,98,000 વોઝ ડિમાન્ડેડ. તો ફરિયાદ પછીનું પહેલું વર્ઝન 3,98,000ની ડિમાન્ડ હતી, નોટ 498 એઝ સ્ટેટેડ ઇન ધ કમ્પ્લેન્ટ. અને એમાં પણ પાછું એવું કહે છે કે 1 લાખના 3 હપ્તામાં રકમની વાત હતી. સેક્શન 8 માટે સાહેબ અગાઉ અમે કહેલું છે. આઈ વિલ નોટ રિપીટ ઇટ. એન્ડ ધેર વોઝ અ ક્વેરી રેઝ ફ્રોમ ધ કોર્ટ ઇવન યુ શુડ meet with this point. Now sir, prior to initiation of this inquiry, no sanction was granted under 17A of the Act is concerned, which has been amended in 18. એના મુદ્દે સાહેબ we rely upon the judgment of કેરલા હાઈકોર્ટનું જજમેન્ટ છે ડિરેક્ટ સાહેબ આ મુદ્દાનું. P. મંજુનાથ એની કોપી મેં મૂકેલી છે આમાં સાહેબ. I will not read the whole judgment, but at the relevant point I will say the relevant paragraph thereof. Then, sir, દસ છ ઓગણીસે સેમ ડે સાહેબ એનું ઇન્ટરવ્યુ થયો, એક દિવસે એનું લાયસન્સ ઇસ્યુ થઈ ગયું, ત્યારે કોઈ ડિમાન્ડની વાત આવતી નથી. તો સાહેબ એઝ પર સેક્શન 8 એણે જે ફરિયાદ કરવી જોઈએ વિધિન સ્ટિપ્યુલેટેડ પીરિયડ એ નથી કરી, તો હી મસ્ટ બી એન એક્યુઝ અંડર સેક્શન 8 ફોર ધ ઓફેન્સ which is punished under section 7. Then, sir, જે 98,000 ની વાત છે, that is after 3 months. Again, section 8 would come in the play. Then, sir, point number 15 is concerned. 27/2/21 નામનું જે સ્ટેટમેન્ટ છે, એમાં નવી સ્ટોરી લાવે છે કે લાયસન્સ ઇસ્યુ કરવાના 2 કે 3 દિવસ પછી મારી પાસે ડિમાન્ડ કરી. while the illicit payment are concerned, it is after 3 months. તો સાહેબ લાયસન્સ ઇસ્યુ કરતા પહેલા હંમેશા પૈસાની માંગણી હોય અને એની રિકવરીની વાત હોય. So it is classic case of post-paid bribe or the demand in my humble submission. એ મુદ્દે સાહેબ આર સૌંદરરાજનનું જજમેન્ટ મેં રજૂ કરેલું છે. એનો રિલેવન્ટ પેરા, it is on the sir para 9 on section 20 of the PC Act. એ મુદ્દે સાહેબ મારી રજૂઆત એવી કે સેક્શન 20માં સાહેબ પ્રિઝમ્પશનનું પ્રોવિઝન આપ્યું, પણ ડિમાન્ડ કરી જો પ્રિઝમ્પશન કરવા માટેનું સાહેબ કોઈ પ્રોવિઝન પીસી એક્ટમાં નથી. ને સાહેબ પી મંજુનાથનું જજમેન્ટ જે મેં કહ્યું નામદાર કોર્ટને ફરીથી એકવાર કહું, 2022 SCC ઓનલાઈન કેરલા પેજ 1834 એનો પેરા 19 અને 20 સાહેબ. There is no post-paid demand concept under section 7 of the PC Act directly applicable to the present case on hand, sir. P. Manjunath's judgment. Yes, P. Manjunath, sir. Para 19. If the facts obtaining in the case at hand are considered on the bedrock of the principle laid down by the apex court, what will unmistakably emerge is that there is neither demand nor acceptance in the case at hand. The demand should be for any work to be performed and acceptance should be towards the said work. એટલે કામ કરતા પહેલાની સાહેબ ડિમાન્ડની વાત હોય અને એને એક્સેપ્ટન્સ બી કામ કર્યા પહેલાની વાત હોય, કામ પત્યા પછીની કોઈ વાત આવે નહીં. The documents produced along with the petition are so unimpeachable that they would clearly demonstrate that the work that came before the petitioner on 24/22, અહીંયા સાહેબ 10/19 તમે લાયસન્સ આપી દીધું છે એમને, was performed and the document was released on the same day itself. If the complaint had complained, સાહેબ 10/19 પછી મેં લાયસન્સ એમનું દબાઈ રાખવી વાત નથી, એ પછી તો સ્પોન્ટેનિયસલી એમણે સાહેબ હથિયાર ખરીદ્યું, હથિયાર ખરીદના ડોક્યુમેન્ટ બી સીબીઆઈ રજૂ કરેલા છે સાહેબ, અને એની એન્ટ્રી પડાવવા આવ્યા છે, એની એન્ટ્રી પાડેલી છે સ્ટાફે ઇન ધ મંથ ઓફ જુલાઈ ઇટસેલ્ફ, 13 તારીખે, 13/7, 13/6 within 3 days. If the complainant had complained that the petitioner had demanded money of the release of the document, that would have been a circumstance altogether different. The complainant is made after 7 days of the release of the document when no work was pending. Haji? જી તો હાજી હાજી સાહેબ, એટલે એ જે કહી રહ્યા છે એ મારો સાહેબ પોસ્ટપેડ બ્રાઇબની જે મેં લાસ્ટ ઓકેઝન પર બી નામદાર કોર્ટને સાહેબ એડ્રેસ કરી હતી, still I stick to my version that post-paid demand or bribe version is concerned, it is alien to the criminal prosecution under PC Act. And for that purpose, I rely upon this judgment, this para, which was not shown. which I am showing, placing it before the honorable court, sir. So, postpaid bribe. Yes, it was argued, but this judgment was not placed by any stretch of imagination or was not placed before the court. So now this is the legal support to my contention. Then, sir, there is another judgment which I have placed, sir, Yashwant BS. 2023 SCC ઓનલાઈન કર્ણાટકા 327 એનું પેરા 8 થી 10 સાહેબ. યશવંત BS ક્યાં છે? જૂના છે પાછળ હશે. પેરા 8 થી 10 7 are relevant. યશવંત BS ના ચુકાદાના. Sir, it is from Karnataka High Court. Sir, wherein case of Prabhu Shankar, son of Muniappa versus State of Karnataka, as well, sir, P. Manjunath is also referred therein, para 8 is concerned. એમાં સાહેબ સેક્શન 8 ઉપર કીધું, સેક્શન 8 of the PC Act. પેરા 8 બહુ લાંબો છે, આખો રીડ નહીં કરું સાહેબ, ટાઈમ નહીં બગાડું નામદાર કોર્ટનો. Then, sir, para 10. It is well settled by the Honorable Supreme Court in the recent judgment as the demand and acceptance is a sine qua non for the Prevention of Corruption Act. Here in this case, there is no demand, acceptance of bribe, and there is no work pending. That is the important aspect for us. With the petitioner as on the date of filing of the complaint. Apart from that, there was inordinate delay in lodging complaint as per proviso to section 8 of the PC Act. Therefore, the FIR and conducting the investigation against the petitioner is nothing but abuse of the process of law. And hence the petition is deserved to be allowed. And accordingly, it was allowed. Now, sir, in the reply, they have narrated one more thing. CBI's reply. Yes, I have inter-se communication through patra lakhine. That is sanction, or that can be presumed to be a sanction under 17A. You have no stand here. એ મુદ્દે સાહેબ મેં ગુજરાત હાઈકોર્ટનો એક અનરિપોર્ટેડ ચુકાદો મૂક્યો છે મારા કમ્પાઇલેશનમાં. એ કિસ્સામાં સાહેબ હાલના આરોપી જે છે પોતે ફરિયાદી હતા. માનાભાઈ ઉર્ફે માનજીભાઈ બાબાભાઈ પટેલ વર્સેસ સ્ટેટ ઓફ ગુજરાત. Sir, it is order dated 15/7/21 by my Lord Justice Nikhilesh Karyal. હાજી સર, પાના નંબર આમાં નથી આપ્યા, અનરિપોર્ટેડ સાહેબ ઓર્ડર છે આવું. કમ્પાઇલેશન પેજિંગ આપણને રહી ગયા સાહેબ. નિત્યાનંદ ધર્માનંદાનો ચુકાદો છે એના પછી આવશે સાહેબ. મળ્યું સર? સાહેબ બીજી કોપી આપું નામદાર કોર્ટને? लो ना, आपका कॉपी दो ना जरा प्लीज. मैं कोर्ट को निकाल कर दे देता हूँ 1 मिनट. લો આપો ને. મળ્યું સર? સાહેબ એ ચુકાદો એમાં સ્પેસિફિકલી સાહેબ જે પેજ 2 પર પેરા છે એમાં 8મી 10મી લાઈન આવશે 17 એ વંચાશે ને અંદર કોર્ટને લેફ્ટ હેન્ડ સાઈડ ઉપર. વોટ ઇટ સર? Learned senior advocate has invited attention of this court to provisions of section 17 of the PC Act, which has been amended in the year 2018, whereby it is inter alia stated that no police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant under the Act, where the alleged offence is relatable to any recommendation made or decision taken by such public servant to discharge his official function or duties without the previous approval of the state government. In the instant case, learned senior advocate has submitted that as per the requirement of the Act, before any instigation of the inquiry into allegation leveled against the present applicant, approval ought to have been taken from the state government, and since approval according to the Act is a prior requirement. So that is statutory requirement, sir. Prior sanction under 17A is must and mandatory. In absence of the same, this court may not permit the investigation into offence under the PC Act as against the same learned public prosecutor. For instance, number 1, state has relied upon the communication dated 30/7/20 and 19/3/21. The identical case is on hand now. As emerging from the reply of the CBI is concerned, એમણે જે કહ્યું કે સાહેબ આજે પત્ર લખ્યો છે અમને મિસ્ટર અસ્થાનાનો કે મિસ્ટર તનેજાનો જે કહેવાય જીએડી ડિપાર્ટમેન્ટ ઓફ પ્રોસિડિંગનો DOPT નો, that may be termed as 17A. It is their sum and substance under their reply. So now here is the judicial support to my contention that it is not the sanction under 17A, sir, and submitted that those documents fulfill the requirement of section 17A of the PC Act. Now, says the court, heard learned party so and so, this court has produced the said documents dated 30/7/20, being communication by the revenue department. Ji, sir. So, yes, sir, here is not there. Now, sir, where evidence is concerned, either oral, yeah, documents or statements are concerned, it shall be produced as a whole, not in piecemeal. Now, sir, on the last occasion, I had drawn the attention of this honorable court towards the document produced by them at D8. So apparently it is prima facie emerging on record that Mr. P.K. Taneja IAS had conducted some inquiry in this respect. It is not denied by my other side because they are relying upon the document. એની અંદર સાહેબ મેં સ્પેસિફિકલી રફીકનું જે સ્ટેટમેન્ટ અને ક્વેશ્ચનર હતું એ નામદાર કોર્ટને નામદાર લાસ્ટ ટાઈમ પર બતાવ્યું, તો આઈ એમ નોટ રિપીટિંગ ઇટ. બટ વેર ઇઝ ધ ફાઇનલ આઉટકમ ઓફ ધેટ ઇન્ક્વાયરી? Why it has been suppressed? So in this regard, adverse inference either is required to be drawn or otherwise, sir, I have produced the Nityanand Dharmananda case, sir, Supreme Court judgment. Even at the court of discharge application hearing, if it appeals to the honorable court that yes, this document is relevant. સાહેબ આજે 3 સ્ટેટમેન્ટોની વાત કરી, એ બધા સ્ટેટમેન્ટો એ જે ઇન્ક્વાયરી હતી મિસ્ટર તનેજા રૂબરૂની એમાં મૂકેલા છે. It is part of the record of before the concern IS officer conducting the inquiry. What is the outcome thereof? So this is high time, Your Honor, and I am earnestly requesting the honorable court to rely upon the Nityanand Dharmananda case. Sir, what does it say? Kindly see. યસ સર 2018 વોલ્યુમ 2 સુપ્રીમ કોર્ટ કેસીસ પેજ 93. લો આપો જરા સાહેબ આમાં મૂક્યું છે છતાં અલગ કોપી આપી દઉં સાહેબ શોધવું ના હોય શોધવામાં તકલીફ પડે નહીં. CRPC section 91 summons to produce documents or other thing. Invocation of section 91 by accused at the stage of framing of charge. No right to divorce the satisfaction of the court. For exercising such power, court has to satisfy that material available with investigator. એવું નથી કે they were in dark આવી કે એમને ખબર જ નથી એમના ધ્યાનમાં નથી. Which was not made part of the charge sheet, has crucial bearing on the issue of the framing of the charge. So, sir, what is the reason to suppress this material document upon which they are relying upon? They are relying upon the Pickett and his inquiry. So, I placing reliance upon this Nityananda Dharmananda case and humbly request the Honorable Court to call for the Pickett Taneja's final outcome from the agency because it is not in my pocket. Even they are not supplying me in under RTI because it is in favor of me. Hence, they are suppressing the same document before the court. A person comes before the court must come with clean hands, sir. Why they are shying? Then, sir, Tarunjit Tejpal judgment is concerned. નિત્યાનંદા ધર્માનંદા કેસ છે પેરા 5 થી 8 રિલેવન્ટ એ મારામાં કમ્પાઇલેશનમાં લખેલું જ છે. Then, sir, Tarunjit Tejpal judgment I have also produced. કે જે પેલું હાઈકોર્ટનું માનાભાઈનું ચુકાદો એની બિલકુલ આગળ જ છે તરુણજીત તેજપાલનું. એનો રિલેવન્ટ પેરા સાહેબ 8.2. હે પેરા 8.2 that for limited purpose court can access the and evaluate. Please, sir, because the no, sir, why? Why? Because there are 3 previous statements of the complainant, whom is the star witness as per their own say. 16/2 ની ફરિયાદ, 23/2 નું સ્ટેટમેન્ટ, 27/2 નું સ્ટેટમેન્ટ ને CBI રૂબરૂ સ્ટેટમેન્ટ. And having the animosity that is to be evaluated by this honorable court at the time of deciding discharge application, sir. એક સાહેબ મેં સૌંદરરાજનનો 2023 ચુકાદો રજૂ કરેલો છે. એનો રિલેવન્ટ પેરા સાહેબ 11.